6, so I guess we'll get started. Welcome to your last class of Trial by Peers for the summer program. Today we're going to go over optional aspects of a trial, which is just in time for your mock trials that will be starting next week. They actually start Monday, so I'm hoping that everyone has started working on them. We did notice that there's a lot of questions coming up through the Discord and through emails we've been getting. So I wanted to give just an opportunity, if anyone had a question, you make sure to type it in the chat if you want to give an, or if you want to unmute yourself. I'm going to give you a little bit of time at the beginning to ask some questions in case it impacts some of the practice we'll be doing. So just to start off, does anybody have anything that they've been working on? The mock trials are in the PM. I guess that's what your question is. Okay. You should have gotten an email that had the schedule, and then there was an additional email that went out with new schedules. So, and they start at 5:30 on Monday.
And I'll add something to that real quick. So even though you guys are in teams, you guys are individually responsible for the whole trial. So if you're having issues contacting your partner, email, text, call Katya and let her know that you're having issues reaching your partner, but just be prepared regardless to do everything for the trial yourself. That's all.
So the going back to the trial schedule, we're doing them virtually like we've been doing the classes. So there'll be one at a time in each window. So I'll be doing one, and Lexi will be doing one, and then Judge Sullivan will be doing one, and then Mike Smith. What was that?
You reverberated really bad if you asked a question there, Max.
Sorry, when I joined, my mic did that.
Oh, okay. Jesselyn, do not switch outlines with opposing counsel. You can switch outlines with your co-counsel if you would like, but you would just be assisting the opposing counsel if you did that. So
Mia, different people have different trial schedules. So we are starting on Monday. Not everyone's going to go on Monday. So like I said, there's 4 dates. So you might have your date as the 21st. So go by what date you were assigned, because like I said, we're doing 4 days worth of mock trials.
Catherine, if you are a witness for one of the groups and the prosecution or defense hasn't contacted you, that's something that they need to do. But in the meantime, like as a witness, you can read over your statement and just be really familiar with it so that when you testify for the mock trial, you're prepared.
And you guys, we got emails. So emails were sent out and then updates were sent out. I know because I received them. If you haven't received them, then you need to don't walk over to your email and make sure it's not in the spam folder and get an email or a call or text, like Lexi was saying, get with Katya and get that email assignment because it's going to be important. So you can, and part of witness preparation and part of what the video was for this week, was about talking to the witness beforehand and going over what they're going to say. Part of that could be practicing your direct examination. You could say, these are the types of questions, or these are the questions I'm going to ask you, and then go through your questions to see what their answers would be. The only concern I have with just simply handing over a list of questions is that you run the risk that your witness is only going to know those questions. So if something is happening while you're questioning the witness and you ask a follow-up question or you ask a different question, they're not going to be prepared for that. It's good to be prepared. It's good to give them an idea of the questions or read the list to them. But just be careful. If you do give them your list of questions, say there might be other ones, but these are the basic, this is what I outlined I need from you during the trial. You can watch the other trials before your turn. I don't know that I haven't heard otherwise, because we all got a start time. We didn't get individual times.
So Tyler, regarding opening and closing, you're going to be giving these statements verbally. It's not a written statement that you give to the jury, like for them to read or for the judge to read. So you can write one to kind of prepare it and get it ready, but you will be like giving it orally and act like there's a jury, even though it's just a bench trial. So there's no jury, just a judge. But yeah, act like you're speaking it out to the jury and the judge.
Okay. The trials we're hoping that they are going to be about 25 to 30 minutes each. They may go over if you get really nervous and go really fast. They may go under a bit, but we're trying to keep them. I believe I'd have to double check, but I believe there's 3 for each session, 3 or 4.
I think that's right. Yeah. 3.
So it'll go a couple, there's 3. Good. Thank you, Patrick. So there's 3 each session, and we're anticipating it to last 2.5 to 3 hours, or excuse me, 1.5 to 2 hours. So 5:30 to about 7:30, possibly a little bit later if people go over. It could happen, possibly a little bit sooner if, like I said, sometimes when you get nervous, you speak faster. So if that happens and you're worried about that, you just need to take a breath and keep going. So yes, there will be a bar exam. It's after the mock trials.
And that will be something that you take individually. So you'll have time. It's not like you sit in a call with us for 2 hours and take it. You can complete it at your own time as long as you complete it before the deadline. So in the mock trial, I'm going to just kind of go through here. The mock trial, the judge won't give out a verdict one way or the other. It's just for you guys to practice opening, closing, direct, cross, everything that an actual trial would involve, but there will not be a verdict one way or the other.
And for the next one, Coco, you do make the assignments, and that's how it is with the real cases by trial by peers. You get a case packet like you've been given, and you get a co-counsel, and it's up to you to decide who's giving the opening, who's giving the closing, who's going to question which witness, who's going to do the cross for the witnesses. All of that is kind of part of the teamwork portion of these of the exercise. So you all will decide who's doing what.
Diana asks, as the defense, do they have to contact the prosecution's witnesses? You don't. I don't actually, Felicia might be able to answer this better. You can, but unless you're going to call them on a direct, you don't have to. But you should be prepared to do a cross exam of the prosecution's witnesses.
And you should be prepared that everything that came out in the witness statement came out so you could cross. But as you're listening to the direct examination, you want to pay a lot of, and this was kind of in the video, but this is good for mock trial too. You already know the parameters of what the statement's going to be because you were given that case assignment packet. Then you listen on direct examination to what questions the prosecution is asking, and you make sure that your examination is within the scope of that direct examination. So if they're not asking and they left out important details for whatever reason, it's not your job. Then don't go on cross and start asking about those important details that didn't come out because they're not in anymore. That's why closing is something that's only can be partially written ahead of time, because you don't know what's going to be able to come out. You don't know what's going to get missed. You don't know. So when you're preparing for your witnesses for your cross-examination, go ahead and read everything, have an outline or a list of questions that you definitely want to ask. But make sure that at the time of the trial, you're paying 100% attention. It's a lot to pay attention to. So when you're going to be the cross-examiner, you're paying attention to the direct exam to see what information comes out. You're listening to the questions to see if there's any objections. You're listening to the questions to make sure that the answers line up so that you can take note and cross-examine anything that you think is unusual. So it's definitely an exercise in paying attention. And I lost the track of questions.
I'm going to repeat this again. If you didn't get an email on Friday from Katya or Patrick with the updates to the trial, you need to reach out to Katya by email or text or call her today. I put her email in the chat a little bit ago. If you need her phone number, ask for it. You guys need to reach out a little bit today. Attorneys are responsible for their own cases. It's their job to reach out to the court. It's their job to reach out to the witnesses. You guys are attorneys in this. You guys need to take responsibility. If you guys didn't get the update, you guys need to reach out to Katya.
And Tyler, this is the last class. We had 4, this is number 4, so we have 4 classes.
Yeah, it's okay if you don't say exactly what's in the witness statement as a witness. If this were like a real trial, the witness would also have they'd be there, they would have witnessed the event, so they would have knowledge about what happened. But for the mock trial, just get the gist of it. You don't have to quote it verbatim. Just read the statement, be familiar with what's in there, and then when you're on the stand, just say it as you remember it.
Okay, I wanted to make sure that everybody got, because we were getting some questions, everybody got the opportunity to ask anything before we started, because this class is largely going to be practice for your mock trials. And I want to make sure that everybody has anything they're wondering about answered. I'm trying to. So to answer the question about what you're allowed to ask, you're allowed to ask about, you have a witness statement, okay? That's what the person said. The witness is going to read that statement. That's what they're prepared to ask about. Sometimes follow-up questions can come from something someone else said. And if that happens and you are pulling information from someone else's statement or somewhere else in the packet, the witness has the right to say, oh, I don't know. So you can ask about other stuff, but you run the risk of the witness saying, I don't know. And then you're kind of done. Because remember when we talked about you can refresh the recollection of something they don't remember, not something they don't know. So it's always important if you're going to be talking to your witnesses today and tomorrow or Monday and Tuesday, depending on when your mock trial is, and you're going to be prepping them. One big thing to remember is if they knew something and they don't know it now, it's that they don't remember. If they never knew that thing, like what color is my car, you don't know that. So you never knew that. So that answer is, I don't know. But what if I asked you what you had for breakfast on June 24th, that is, even though you don't know that now, it's actually, I don't remember, because you did know it at one point, you just don't remember it now. So it's up to you. The whole point of the mock trial is to see what you guys come up with, to have you think on your feet, to prepare and get ready for trials. And if you want to take some risks, there's no one's going to stop you, except for just know that there's some consequences to doing that. You might have someone telling you, I don't know, and you have to move on.
Mackenzie, did you type your question in the chat? I see it. I want to make sure it's the same question.
Yeah, I did.
Okay.
Thank you.
So when you are in front of a jury for trial by peers, it's former defendants. So the video is right. Like, it might be a little hard to relate to them, but what you can try and do, like, there's a lot of different strategies. Try and emphasize, like, the consequences of the defendant's actions. Try and differentiate it from, like, their cases. I mean, you don't know what those cases are, but a lot of the trial by peers cases will be similar facts. A fray or fighting in school is a common offense. Try and differentiate it. Try and make it, different. So the former defendants in the jury, oh, this is worse than what I did. Like, so they can see. It's difficult, but you just gotta try and be creative.
Okay, thank you.
So because we're doing virtual trials, it's going to be hard to relate to every person that you deal with. Just try to watch watch people on the video. Watch it a little bit better because you can see facial expressions a little bit better when we're all on video versus being in person. So when you're trying to relate, I'm trying to answer the question how to relate to the jury if you're on the prosecution. Oh, okay, you mean sorry, I took that as the mock trial. So if you're talking about mock trial, it's just it's a bench trial. So just try to pay attention to facial expressions. Maybe that's how you can relate, or relating to the jury is a whole other issue. So if you're in a real case and you have a real jury and they are kind of listening to you and you are talking to them, when you go to do your closing arguments, what I was getting at when I was talking about that, the perfect example is a real life example that I had a few years back in the Trial by Peers program. It was the story similar to our mock trial of a fight. And the fight happened between two girls at school. And one of the girls, who was our client, had large hoop earrings on, and throughout the fight she had hoop earrings on. And the question at hand was, our defense was that she didn't start the fight, that this just happened to her, and the prosecution, of course, was saying no, she's a willing participant. Okay, you get up at closing, and there was a video, by the way. Of course, it didn't show the beginning, but it did show them engaged in a scuffle. So what we were able to argue was that, look at the video, look at her. She did not come to school to fight. She had white pants on and she had these large hoop earrings. And who goes into a fight with large hoop earrings? That's just dumb, because during the fight they can be pulled off. So as she's arguing, of course my client didn't intend to go and get in a fight that day at school. Someone just attacked her. She mentioned the hoop earrings and said, listen, would you go, no one goes to a fight with giant hoop earrings on. And so that was relating to the jury, because there was jurors kind of nodding along and going, yeah, that's true. I wouldn't start a fight with giant hoop earrings on. So that's kind of how you relate to the jury, is say something that don't go in there and try to right off the bat argue like a Supreme Court case or something that's really not going to hit home as much as something that they deal with kind of every day, or that they already know. That's how you kind of relate to the jury. Okay, so I'm lost, sorry.
So I think since we have an hour and a half left, I think we should go over the homework a little bit, specifically the video handouts. I know there's been a couple questions about the exceptions to hearsay. So maybe we can talk about that a little bit, since that's kind of a tough topic. And then after that, maybe we can go back to trial questions.
All right, you want to do that then?
Yes. Give me 1 second. So hearsay in general can be kind of confusing, and you kind of just have to see it in a trial a few times before you can get like really a handle on it. So the fact that you're confused about it isn't necessarily a bad thing. So hearsay in general is an out-of-court statement that goes to prove the truth of the matter asserted. That's a big, long definition, but it's pretty simple. So hearsay generally is a statement that was made out of the courtroom, so not in front of the judge, not in front of the jury, that goes to prove the truth of what is being said. So if, I'm trying to think of a good example for hearsay. If your witness is on the stand and they say that they heard the defendant say they were going to go to school to beat up, the victim, that's hearsay. It's an out-of-court statement that the defendant allegedly made to the witness, and it goes to prove the truth of the matter. Did the defendant beat up the victim? So that's a common example of hearsay. As far as hearsay exceptions, there are hearsay exceptions, and then there are things that are just not considered hearsay, even though under the definition they might be, but the courts just don't consider them to be hearsay in the first place. A confession is not hearsay, even though it was made out of court for the truth of the matter asserted. So if the defendant tells, a nurse or a police officer or their friend, like, hey, yeah, I picked a fight. Felicia, if you're saying something, you are muted. No? Oh, okay. I'll keep going. That's cool. The confession is not considered hearsay. It's just a rule. You just have to get used to it. There are exceptions to hearsay. The biggest one that you're going to see in trial by peers is police reports. Police reports, by their definition, are hearsay. But in trial by peers, we often can't get the police officer to come physically to the trial to testify. They're on duty. They've got other cases that they need to testify in. So for the sake of trial by peers only, a police report is a hearsay exception. You can just ask the judge to admit it. Those are the two biggest exceptions to hearsay. I know, Abby, that was your question. If people have follow-up questions, Ronald Smalls claiming he was threatened to be shot be considered hearsay. I guess it depends, which is a very typical lawyer answer. If you're the prosecution, you would argue that it's not hearsay, because shoot, I think I got that screwed up. Felicia, can you chime in a little bit on that?
Sure. So another one of the, because hearsay's got a lot. Another one is describing a present sense impression, and just like excited utterance. So the whole point about would it be considered hearsay is going to be based on the argument that the judge gets. So Ronald Smalls claiming he was threatening to be shot. Obviously, defense wants that in. So the prosecution is going to say, no, that's an out-of-court statement for the truth of the matter asserted. You shouldn't allow it in. The defense is going to hold state of the mind of the listener to explain what happens next. So if he was claiming to be shot, that's going to set up the idea that he was acting in self-defense, that he has a present sense of fear, or that it goes to the effect of the listener to say he may need help later, he's trying to communicate something else. So there's a bunch of different little ones in there that you can start to argue. And when Lexy says it depends, it really does depend on the strength of the argument that you make. So it's more about what would you argue and less about what is the ultimate answer. Because, and this has happened in real life, it's happened in mock trials where we run the same mock trial and some people got some evidence in because they argued one way, and some people didn't get that evidence in because they chose a different way to argue. So you could pick which piece that you want to argue, and that's what's going to be more important. So could it be considered hearsay? Sure. Could it be considered an exception? Sure. So you're going to want, if you're on the defense, you're going to want that in, because it really goes to the effect on what is going to happen coming up on that fight. Was he actually a willing participant? So I'm not sure that answers your question, besides just kind of supporting the fact that it depends on the argument that you make at the time. You are allowed to use the police report.
The police report is considered a hearsay exception for trial by peers only. So you will always be able to get the police report in.
Right. Okay. Was there any more homework questions that I missed?
I only saw the ones about hearsay, but if you guys have questions, type them in the chat or do the raise hand question or raise hand feature.
Okay. So I want to go ahead and start, because it's already 11:30. So I wanted to go ahead and start having you guys, part of the homework was to prepare your opening statements. I want to be able to have you guys give the opportunity to try that out. And I'm going to be nice and ask for a volunteer. If anyone is ready to kind of go first and give me their opening statement, you can be defense, or you can be, no, you know what? Let's do a prosecution. So anyone who's counsel for prosecution. Okay, Caleb, unmute your mic and let's hear it.
Okay, can you hear me?
Yes.
Okay. Good morning, and thank you all for being here today. I'm Caleb Kuhn with my co-counsel Christina, representing the state of Nevada. The evidence presented today will show that on February 5th, Ronald Smalls was seen in a physical affray with Michael McKinney. The evidence will show that seeing that fight, Assistant Principal Tiffany Seibel called CCSD police to the scene. The evidence will show that arriving at the scene, Officer Paul Carapucci and Officer Jerry Lafredo observed the two students fighting on the second floor of the school. The students were then taken into custody and cited for disturbance. You will hear the witness testimony of Michael McKinney, who is cited to be in the affray with Ronald Smalls, and you will hear about the events leading up to the fight, including prior acts of aggression and violence from the defendant. Following the eyewitness testimony, you will hear myself and my co-counsel Christina argue why it is essential to determine a verdict of guilty for disturbance at school for Ronald Smalls. Thank you.
So that overall was really, really good. For a first shot, that was well structured. You gave me I could definitely follow your roadmap. Definitely gave us something to follow. The only caveat I wanted to bring up was I wanted to make sure in real life, you would have controlled what witnesses you called, and you, when you said you would hear from this person, you would hear from this person, the evidence will show this. Just know that you'll be calling those witnesses to say those things, and just beware of over promising in the opening statement, because you might not get it all in for the mock trial because you're limited on the witnesses. So make sure if you are going to go with that statement, which is awesome. Don't get me wrong. It was really, really good. Make sure that you have a plan to get each piece of that evidence that you said in the opening. Does that make sense? To come into the trial? Okay, good. Okay, so do we have an opening from the other side? Okay, go ahead and unmute your mic, Coco, and
yeah, I doubt I'll be as professional as Caleb, but I'll start right now. Good morning, judge, jury, and ladies and gentlemen of the court. Throughout the tribulations of this trial, I only ask one thing of you: to be human. Today's case revolves around children who without this system would potentially have their lives ruined from one incident. I ask you to keep this in mind throughout the coming statements and focus on the reasoning of a child without a clear state of mind. My client, Ronald Smalls, just like you or your friend or any other 16-year-old, had been playing a game of football with the prosecution before it escalated into a fight and then eventually a full-scale threat of gun violence. I'd like for you to imagine the panic that settles in at the mere mention of this happening to you. Now I'd like you to transfer that same energy onto a child whose life was just threatened after playing a game of football is what we are in this courtroom to determine if they're guilty or not. Previously, I mentioned the only thing you should take away from this statement is to just be human, and I still affirm with that mindset. Reynolds stated he didn't want to fight, and it was inflicted on him. In his statement, he says that he wasn't going to fight McKinney until he was pushed by him. On the day of the statement, McKinney allegedly insists on bringing in his brother to shoot him, which would have been extremely threatening on the receiving end. All actions were warranted out of distress for Smalls' own life. So as the statement concludes, the evidence throughout this case will not prove the prosecution's case. Judge and jury, the only fair verdict in this trial will be not guilty. Thank you.
Coco, that was really good. You did a really good job setting it as, he's just a kid. Put yourself in his shoes, which I will caution you. You might be able to get away with it in trial by peers, but in court in front of a real judge, you can't tell the jury to put themselves in the defendant's shoes. But you did a good job. He's just a kid. He was threatened. He was just playing a game of football. Like, this got out of hand. He's just, he was scared. So you did a good job setting that up, making your defendant very relatable, especially when your jury is a bunch of high schoolers who are former defendants. So I think you did a really good job.
I agree. I just have one thing to add on to that. When you were talking, you said that the defendant was playing an innocent game of football with the prosecution. He wasn't playing with the prosecution. He was playing with their complaining witness. So he was, just go ahead and strike out with prosecution. Just say he was playing an innocent game of football. Okay. Then it turned into these things that you talked about. The other thing is that I know you got the information from the statements because that's what everybody did. Turn those clauses into the evidence will show that. So instead of saying in his statement he said that, you will say the evidence will show he said that. Does that make sense? And then other than that, other than those 2 changes, I would be totally impressed if you gave that as is. Okay. So we had 2 really great opening statements and I felt like those are pretty good. They covered everything. They gave us a good roadmap. I want everyone to pay attention to how I could feel a theme throughout both of them. I could definitely, Coco is setting herself up to have a human client. Humanizing the defendant's always the defense's job, so that's really good. Does anyone else want to give a opening statement for either side? Okay, I don't blame you. Those were really good. So we got really good examples. I want to see, let's move on then. We have really great examples of opening statements. We can move on to some direct examinations of the prosecution's witnesses. So who is playing a witness in the mock trials for the prosecution? I could go look it up. But if anyone, so no one on here is, okay. Thank you, Mia. Thank you, Myra. All right, so I have 2 prosecution witnesses. Hopefully they're ready. Who is playing besides Caleb, who is a co-counsel for prosecution? Okay, do one of you want, well, oh, some of you are doing both. So that's good because you'll have the questions memorized from both sides. So why don't we pick, how about Catherine is the witness and Mackenzie is the attorney? Let me hear your direct examination.
Should I just like unmute and say it?
Yep, why don't you practice asking her so she can practice answering and we'll see how it goes.
Okay, so the
Michelle McKinney, right?
yeah.
Okay.
Please state your name and spell it for the record.
Michelle McKinney, MICHELLE. And
Mr.
Sorry.
Mrs. McKinney, how old are you?
15 or 16.
Are you still a student?
Yes.
Which school do you go to?
Monaco High School.
What grade are you in?
9th? 10th?
Are you engaged in any activities at school?
No.
Are you involved with any sports inside of your school?
No, outside of regular PE class.
Yeah, like any teams, sports teams?
No.
So it says that they met in football. This isn't for the witness, but so I was trying to bring like football into this. And it says that you played football, so.
Yeah, but that was just part of PE class.
Oh, okay. Okay, sorry. Were you on the football team in January 2014?
Yes.
Do you know the defendant, Ronald Smalls?
Yes.
And how do you know the defendant?
I've seen him around school, and sometimes he plays rough with people during sports.
In January of 2015, was Mr. Smalls also on the football team?
Yes.
Do you see Mr. Smalls in this courtroom today?
Yes.
Could you please identify Mr. Smalls?
He's over there.
Ms. McKinney, the defendant here is accused of causing a fight on January 5th, 2014. Are you familiar with the details of this incident?
Yes.
What do you know about this incident?
It took place on the morning of February 5th, and I was involved in it.
Who started this fight?
Mr. Smalls.
Where were you attacked?
the head.
And you were on school property, and were you on school property when this fight occurred?
Yes,
Where were you on school property?
the second floor.
And how did he attack you?
He hit my head and he pushed me down.
No further questions.
What?
No further questions?
Oh, yes.
Okay, good job. A few notes, and I'll work my way backwards. You skipped when you asked her where were you attacked. There is a little more foundation that needed to be laid there. You asked a question. He's being accused of all this stuff. Are you familiar with the details? And then when you said, you would say, how are you familiar? And give her a little bit of time to kind of give you the story rather than handing her the story, so that we could lead up to attacked a little bit better. Were you injured? How were you injured? And then where were you attacked? Something like that, lead up to it a little bit. The other thing, and you caught that she was female, which is in mock trials so important. Thank you for doing that, because too many times you're talking to a woman, you're saying Mr. The next thing is identifying Ronald Smalls. You would say, can you identify Mr. Smalls in the courtroom here today, or I guess you say in the courtroom here today, by pointing him out and identifying an article of clothing he's wearing. So they can do that on the video. Say, identify an article of clothing. She can say, oh, he's in the blue sweater. He's over there in the blue sweater. Okay, that helps identify who he is. Other than that, you did the chain of events really well. There were some things that you want to be careful about. That could lead to some objections, but I'll wait and see if anyone else came up with any. But other than that, that was really good. And if you do that for your mock trial, I think you'll be able to get all of that information in. As the witness, Catherine, do you have any feedback for those questions? Did any of them confuse you?
Just only the one about, can you point him out in the courtroom, because I don't know how to answer. But that was good.
That makes sense too. Oh, and what came up also during your questioning is kind of and this is common. He's playing, they're playing football together, and it's not clear, are they playing football as part of like PE class? Are they playing football like on a team? And is it like a sports that you're associated with? So you might want to just, instead of bringing up team sports, just cut to the chase and say, have you played football at school? Do you think
Yeah,
you could?
that makes sense.
No, that's good.
Yeah.
Does anyone else want to try? Okay, Marie, which one do you want to do? Your defense for Ronald Smalls. Do you want to cross-examine Catherine?
Are you asking me? Sorry.
No,
Why
I'm
don't you do
Oh,
cross
okay.
for Catherine?
You have to go across. So you're going to go one more time as the witness, and this time she's going to cross-examine you, okay? So Marie, unmute your mic and go ahead and cross her.
Am I playing Smalls this time?
She's defense for Ronald Smalls, so you would be the same witness. Since she's defense, she's going to cross-examine you.
Sorry.
So you're the same witness.
Okay, so I'm supposed to only cross-examine them on what the attorney asked of them?
Yes, or what you want to be able to, unless, okay, you can ask questions outside of the scope, but it might garner an objection or an I don't know If you think that there's stuff that is better left unsaid, then let it leave unsaid. If you think there's stuff you need to bring up, then try it and see what kind of objection you would get. But I want you just to try it for right now, okay?
All right, so your name is Michelle McKinney, correct?
Yes.
You're a student at Monaco High School, correct?
Yes.
And you play football at PE sometimes at Monaco High School, correct?
Yes.
Do you often get into altercations during football games at Monaco High School?
Sometimes.
Sometimes. Do you often feel offended by the play of other players at Monaco High School?
I'm sorry, you cut out what?
Let me restate that question actually. Was there ever a moment in time where you felt angered by or frustrated by the games at the football games at Monaco High School?
Yes.
Was there ever a time that you tried to fight a student over a game at Monaco High School? A football game at Monaco High School?
I tried to defend myself.
You tried to defend yourself from somebody?
Yes, from Mr. Smalls.
That somebody was Ronald Smalls?
Yes.
So this happened during the game?
Yes.
And were you ever held back from fighting somebody?
Yes.
You were held back from trying to fight Mr. Smalls?
My friends were holding me down because I was trying to defend myself against him.
Your friends were holding you down because you were trying to defend yourself against him?
Yes.
So you believe that your friends were trying to hold you down from defending yourself?
Yes.
From defending yourself from Mr. Smalls again, correct?
Yes.
And did Mr. Smalls ever try to pursue you after that? Well, after that, when you were held down by your friends?
Did he ever try to attack me?
Yes.
Yes.
At that game? No, on that day. Sorry. At that football game, did he ever try to attack you again?
No.
But you still believe your friends were trying to hold you down from defending yourself?
Yes.
Okay. Did you and Mr. Smalls ever get into an altercation later?
Yes.
And you believe that Mr. Smalls initiated those altercations?
Yes.
Okay. Did you ever say anything to Mr. Smalls following that football game at Monaco High School?
I said something to somebody else that triggered the fight, but I wasn't directed at Smalls.
It wasn't directed at Smalls, but you said it to somebody else that triggered the fight? Is
Yes.
that what you said? And was that somebody else near Mr. Smalls?
Yes.
So it was in a proximity where Mr. Smalls could hear what you said to them?
Yes.
So you believe that what you said to somebody else is what triggered the fight with Mr. Smalls, but it was in the proximity that Mr. Smalls said that, but it was in proximity of Mr. Smalls that he could hear what you said to him, correct?
Correct.
No further questions.
Okay, so you in the beginning, Marie, you had the cross like pattern, yes or no questions. Don't let the defendant, don't let the witness, elaborate, which is the point of cross. So you started off really, really strong. And I think you may have just kind of lost your way a little bit in the questioning, which is okay. Cross is a lot more difficult than direct. Direct is really easy. Like, hey, tell me about this. Okay, tell me about that. Cross is more you testifying, like the video said. So if your witness starts giving you long, detailed answers, like Catherine was like, yeah, they were holding me back because, I was trying to defend myself. Well, that's not what I asked you. Were they holding you back? Yes or no? So you want to try and redirect your questioning if the witness starts to elaborate and kind of doesn't help your case anymore. But you started off really strong. Cross is something that takes practice. So you've got the good foundation. You just need to maybe get a little bit more familiar with the statement a little bit.
Okay. Well, I was like, I didn't know what to do when they.
It's okay. Like I said, cross is a lot more difficult than direct. A lot more difficult.
And I just wanted to bring it up because in case you didn't see it in the chat, Marie, it became really obvious that you asked the same question 3 times. And first, there's no need to do that. Don't ask her, because then you run the risk that she's figured out that she answered incorrectly and she should say something else, and then it might go off kilter for you there. You really truly didn't need to ask that question. So your friends were holding you back from defending yourself? That was the question that you asked a couple of times. But you picked up, the good thing is you picked up on a really interesting point. She was saying, oh, I was only defending myself, but my friends were holding me back from defending myself. That's strange, right? So don't let it go. But don't question her over and over again about it. Put it in your closing argument. So the closing for your cross should be, how much sense does that make? She's saying that, her version of events, she'd have you believe that her friends were holding her back from defending herself. What kind of friends would hold you back from defending yourself? That kind of argument is really good when you got her to say that on the stand, but just don't continually repeat it, because now everyone knows, oops, she said something she shouldn't have. Now on redirect, Mackenzie can go up and clean it up and say, oh, hey, when you said your friends were defending, were holding you back, can you describe what was, and get more detail and pull all of that good, pull all the sting out. And so it kind of would dampen it down a little bit. Does that make sense?
Yeah, makes sense.
Okay. Because I hope whoever does the closing argument would be able to say, hey, remember she said that? That doesn't make any sense. That version of events doesn't make sense. What makes sense is what my client's been saying.
And to elaborate a little bit on that, I know you guys are preparing like your opening statement and your closing statements and your direct questions and your cross questions. But part of what makes an attorney stand out and makes them a good trial attorney is the ability to be adaptable. You aren't just reading off your list of questions, no matter what the witness says, no matter what the body language of the judge or the jury is. You're paying attention to what's being said. You're paying attention to the body language of the judge and the jury and the witnesses, and you're adapting to that. What Felicia just mentioned, like she was holding me back. They were holding me back from defending myself. That doesn't make sense. So that's something that you would want to include in your closing statement as the defense, even though you may not have actually written it down. So just make sure you listen, try and adapt any new info or body language or whatever into your arguments if you think it'll help your case, even if you weren't prepared for it.
Okay, so the question, Jillian's question is, when doing direct, could you say, tell me of the event of, or do you need to shape the question to get them to tell their story? The preferable method is to shape the question to get them to tell the story. You want, so Catherine should have been telling the whole story of this dramatic event that she got hit and all this stuff on direct. And then when it comes time to cross, that's how you know that Marie's cross was overall really good, because she just said yes a lot. So you want them telling their story on direct and then just saying yes on cross or no. Does that answer your question, Jillian? I'm not sure what you meant. Yeah, okay. When she says she gets into altercations, sometimes Kootenai says she causes problems. Max, Julian, that is the benefit of having different mock trials and having different witnesses and having different things. You could, if you are the witness, you could say it. However, it makes sense to you. As long as you're sticking to the information that's in that statement, the way it's worded is up to you. It's going to be better if you say it, the way it's written, but it's up to the lawyers to try to get that interpretation out and argue it. So yeah, you could also say she causes problems because aren't altercations problems? So that's basically the same thing. So you could say it a couple of different ways. Yeah, oh, it looks like she answered you.
Sorry. Yeah, I didn't want to interrupt you.
Sorry. Okay, do we have any more questions about questions? This is sometimes the most easy part, and it's also the most frustrating part, because the big thing is you don't want to forget anything, but you don't want to drone on too long where you lose your jury. So does anyone else have, everyone's ready for their questions? Okay, so do we have anyone playing defense witness who wants to do direct for the defense? There's no one? Oh. So I only got two. So are you both,
Yeah.
does someone want, who wants to play the witness? I want to show everyone the other side. You saw it,
Who is playing Ronald Smalls specifically
okay.
at some point? Okay. So Ariana, you can be Miss Smalls. And Leilani, why don't you do a direct for the defense for Miss Smalls, Ronnie Smalls? And you guys can unmute.
Wait, what?
Leilani, are you a defense attorney for Mock Trial?
I'm the defense witness.
Okay, I misunderstood that then. Ariana, are you a defense attorney or are you witness?
Witness.
Okay.
But at the
Ariana,
same time, I'm
it's
also
okay.
a defense attorney. So
Okay, so we'll just switch them then. Leilani, you can be Miss Smalls, and Ariana is going to be the defense attorney doing a direct exam of you.
okay.
Okay. Do I just start?
Yeah, you can just start whenever you're ready.
Okay. What's your name?
Rochelle Smalls,
How old are you?
16,
What grade are you in?
10,
What school do you go to?
Monaco High School.
Did you go to school on Friday, January 31st?
Yes,
Did anything happen that day?
I got into an altercation with another student.
Would you mind explaining how?
So we were walking down the halls after the assembly, and Mr. McKinney threatened me and said that that his brother had a gun, and then that's how the fight started.
Was that your first time seeing Mr. McKinney?
No,
So what was your first time seeing him?
I'm on the school football team with him, so I see him quite frequently.
Are you guys friends or share the same friend groups?
Huh?
Are you guys friends or share the same friend group?
No.
After the whole situation about his brother, did you see him again?
No.
That's all.
Okay. So you started off well. Again, direct is, just let the witness tell the story. You're just kind of getting it out of them. You kind of jumped a little bit. You talked about, like, have you seen Smalls? You guys run the same group of friends. Into like the brother, and you need to lay a little bit more foundation. Like, okay, like, was there something going on with, the brother? Like, what's going on with that? Sometimes you'll have witnesses that are on direct are a little bit difficult to coax stories out of. If that happens, you might need to ask them a little bit, not leading questions per se, but can you tell me about the event that happened on Friday? Did something happen with you and Miss McKinney? Tell me a little bit more about that. So that kind of happened. You kind of had a little bit more of you had to coax the witness a little bit more. And sometimes that'll happen. It just depends on who your witness is. But overall, I think you did well. Just make sure you get the full story out on cross exam or on direct exam.
To piggyback on a little bit what Lexi was saying, I agree with her. The foundation, and I just want to suggest a way of doing that. Instead of just jumping to the incident with the other person, you can just start asking, because remember Coco was saying that, she's just a kid, like she was scared, kind of get some information about her to the jury first. I'm a regular kid, I go to Monaco High School. Here's a little spot where you could add some stuff in, what grade are you in? Do you do activities? Oh, sure, I'm on the football team, that kind of stuff, just to kind of paint a picture of who the person is a little bit first, and then get into the altercation so that the jury has a minute to kind of get used to your client first. So that's kind of the kind of foundation that I would have laid. But other than that, it's good. And we already have a volunteer to do the cross. So we're ready for cross exam. You can unmute yourself and cross her now. Tyler.
Okay, thank you. Do you know the rules of flag football? I don't know. Are you unmuted? I don't know.
I'm gonna say yes.
Okay. So you broke the rules on January 31st?
I don't believe so.
Okay, let's move on then. Were you angry that day?
Not at all.
Not at all. Okay. So if you weren't angry, do you think you fought Mr. McKinney just for fun? Yes or no?
No.
No. Okay. So the next day you were with McKinney's friends?
No.
You in a witness statement you gave, you said you were with Mr. McKinney's friends?
In the witness statement, I had said that I was walking down the hallways till I bumped into Mr. McKinney and his friends.
I'm sorry, now I'm very confused because the witness statement. I'm sorry. Yeah.
Me too.
Yeah, okay, I'm very confused now. I think I'm gonna stop because I'm thrown off now.
That's okay. Hey, that happens. So let me pull up the witness statement. Do either one of you have it in front of you?
I do.
I
Yes.
do.
Oh, there it is. Okay, hang on. That's small. Signature on Friday. We're playing football. Went to the bus.
So one thing I'll say, Tyler, you actually had her in a really good spot. You asked her, like, were you with McKinney's friends? And she said no. And you followed up and said, but in your witness statement, you said that you were, right? And she said no. Well, she's just contradicted herself. Either she lied in the witness statement and she wasn't with the friends or McKinney at any point, or she's lying on the stand. It doesn't matter what she says after that. Either way, you have her. Either she's lying in her statement or she's lying on the stand. And the whole point of cross-exam is to discredit the credibility of the witness you're crossing. So you got that. You didn't know that you had it, but you did. And that's
yeah,
good.
I see that now. But at the time, I had a lot of things I expected to come out of her mouth. No, at the beginning was not one. So I was thrown off from the beginning. And then I got her to that point, and then I was really confused. So yeah, next time though, I see how I did that. Yeah.
Yeah, no, you were right there. You just got a little thrown off because I don't think you were expecting that answer.
And that can happen. And that's the favorite moment of take a moment of reflection and just ask, can I have a moment of court's indulgence? And go back and look at the statement and ask your question again. It's okay. It's okay. Don't get so thrown off that you have to keep asking your question. You can stop, ask for moments of court's indulgence, walk over, pick up the statement, look at it, say, okay, now I see, and ask. Because if that had been in Ronald Small's statement, that would be an appropriate impeachment opportunity for you. And you almost get there when you say, didn't you say in your statement? But it looks like it was in McKinney's statement. So Friday, the very next day after the assembly, I was walking to the bus. He snuck up on me. Today, he was with my best friends, Perry and Kenny. So he was with their friends, but it was in the other statement.
So could I still use that to impeach, or would I just have to move on?
You would just
Oh,
go ahead, Lexi, sorry.
Oh, sorry. No, go ahead, Felicia. You were answering the question.
You can impeach with anything, but the end of the day, if you were stuck in the moment and you were crossing and you found it was in the other person's statement, you can have her read it and say, does that say that you were with her friends? So is it your testimony that you were not with her friends? Yes, you can impeach, but you're going to want to make sure that when you crossed the McKinney witness on when she was on direct, you're going to want to bring, that is one of the things that's going to need to come out in order for you to cross. Oh, wait, your prosecution. Sorry, now I got confused. You're going to want that to come out on your direct exam so you can cross Ronald Smalls about it. Okay. And then in closing, you argue the two because you got the two pieces of facts out. So when you were doing direct at McKinney, you got out, yes, Rochelle was with my friends, Perry and Kenny. And I said, I walked up to them. That the defendant was with the two friends at the time of that incident when McKinney walked up. So once that is out, if Rochelle Small says during your cross, I wasn't with her friends, no, then you'd say, okay. And you might want to just move on and say, she obviously wasn't being truthful, judge, in your closing or jury, because as you heard on direct, she was with the friends and then she denied it on cross-examination. So you could play it two different ways. You can impeach, or you can let it go and argue it, the contradiction in the closing. But, and it's true, I'm reading some of the,
real quick, Gillian Gillian, I don't know how to say your name. You can ask your question.
okay, go ahead.
You got it. I've been trying to type it and I just can't figure it out. So I just figured I would unmute. So in that situation, if the attorney was incorrect in what they were saying, would the witness in that situation be able to say, that wasn't in my report, that was in the other person's report? Or would who would that it just has to let it go?
You could, on redirect, the defense could take a moment and say, Miss Smalls, you didn't state that in your report, did you? No, that was in Miss McKinney's report, wasn't it? Yeah. And then the judge knows, hey, that was not, actually something that Miss Smalls said. So.
Thank you.
And the reason the witness wouldn't say it is because presumably the witness didn't read the other statement. So the witness doesn't know where it is, presumably. You're playing witness, right? I just know what's inside my statement. So.
One last question.
Oh, go ahead.
Just one last question on if I were to want to impeach. In order to do that, I would have to use Mr. and Mrs. McKinney's witness statement and quote unquote like refresh his memory maybe with it. But the statement would be important for it, correct?
The answer to your question is yes, the statement would be important, but not to refresh the recollection, but to impeach.
Oh, okay. Thank you.
And then Catherine, go ahead.
No, I was just going to start.
Oh,
sorry.
Oh, sorry.
I just
So
saw
say,
you.
oh my God. So say you're the attorney and you're cross-examining a witness and you do get them to make a prior inconsistent statement. How would you go about actually impeaching them? Would you just ask the judge, like, I'd like to impeach the witness? Or
so how you would do that? So you just told me, so say, let's put around Small's statement, right? Because we got Ronald on the stand, or Rochelle. And the statement just starts, it all started on PE on Friday. And they were like, oh, it didn't. So they say something different on the stand, like it started that day. So then instead of saying, Judge, I want to impeach, you get the answer out that contradicts the statement. You go get the statement from your table, because you're going to have that printed out. And you say, isn't it true that you gave a statement at the time of the incident? And that's the yes. And then you can show them the statement, have them read the first thing and say, okay, isn't it true that you said this at the time? And then they're going to say, well, yeah, I did write that. And then that's when you impeach. That's how you impeach. You don't ask to impeach, you just do it.
so you get them to read both inconsistent statements and then you just say no further questions?
Well, it depends on if you have more questions. But if you're impeaching, your question is, which one is true, right?
Right.
Did you write the right thing at the time, or is it right now? It kind of goes back to what Lexi was saying. Either you were telling the truth then, or you're telling the truth now.
Right. But I just want to know how you
do it.
Yeah.
You get the wrong statement.
Sorry.
Whatever question he answered, the answer is wrong in some way, or different. Different than what they said before. And then you get to show them this statement and then point out where the inconsistency is, right?
Right.
And then
Felicia,
go ahead.
do you just want to do like a quick example between you and me to kind of show them like how to impeach? Like I'll be Smalls and you can be crossing me and you can impeach me. I have the statements up, so.
I do too. Let me see what I want to ask you that you cannot say is true. Well, we'll just use something easy, like when did the fight start?
It started at in science class on Thursday.
So Ms. Smalls, when this incident happened back on January 1st or whatever it was, you gave a statement in writing of what happened at the time. Is that correct?
Yes.
Okay. So I'm going to go get it and I'm going to show it to you. Is this your statement?
Yes.
And could you read the first sentence quietly to yourself?
Okay.
Okay. And in that statement, you wrote it all started on PE on Friday. Isn't that true?
Well, that's what I said in my statement, but I was just rattled. Like I just gotten out of an altercation. That's not right.
But it does say it all started on Friday, correct?
That is what I wrote down. Yeah.
Okay. And now you're saying that's not true.
Yeah, I'm saying it started in science on Thursday.
Okay.
Yeah. That's all you have to do.
That's all you have to do.
So then you're just done.
Well,
Okay.
I got out the difference. I'm not done with that point. In closing, I'm going to argue the inconsistency, right? That's why you
Right.
have the inconsistent statement. You use it later in closing. I don't have to badger her right now about it. And then
I
in
see.
redirect, whoever was directing her is going to want to go and fix that in some way to go back and say, okay, because she's trying to give you an out. Well, I was rattled. I would have just gotten into an altercation. I was scared. I got confused. That's what the explanation is going to be. But it's simple. You don't ask to impeach. You just kind of do it.
I see. Okay. Thank you. I'm sorry.
No. These are good questions because it comes up, especially in mock trials, because you want to make sure you're answering the questions right, but things happen.
Right. I just thought you have to like actually impeach. I didn't know it was just a term. Okay.
Mira, you'll have time on your opening to be like, Your Honor, before I call any witnesses, like I'd like to move that the police report be admitted into evidence, and the judge will ask you why, and you'll say why, and they'll make a decision then. Don't ever assume that something's already admitted into evidence. You have to put it there.
You can ask cross-examination on what's on the report, but be careful because make sure it's something that witness would know. That witness, remember the witness didn't read the report, even if everybody else gets to read it.
I have a question.
Go ahead.
In the police report, it doesn't state that Smalls was with McKinney's friends. So could they use that to overrule it?
It says it in McKinney's statement that Smalls was with McKinney's friends and McKinney walked up to him. But you're saying that details left out of the police report.
Yeah.
So to kind of build on that, it's your job as an attorney to kind of get the full picture of the facts through all these different sources, through the police report, through the defendant's witness statement, through McKinney's witness statement. There might be facts missing from one statement that are present in the other two, or vice versa. And it's your job to figure out, is that important enough to bring up?
Okay. Okay.
So because you guys don't have the police report, I would suggest making that motion for the police report due to an unavailable witness, because you don't have the police officer to come testify about what normal life you would, but we're doing kind of a shortened mock trial, so you only get the one witness. So I would, Philippe, I would ask that you admit the report at the beginning of the trial. We'll see how many people remember to do it.
Yeah, I know Mia's had her hand up on and off for a little while. So Mia, ask your question, then Nika can ask hers. If you want to unmute Mia.
Sorry about that. But someone brought up a good point. And McKinney said that, like in the written statement, he said that he was with his friends, and then that's when Smalls got mad and they started fighting. But in the written report, he said that he only said that Smalls got mad. So I think the defense could say that McKinney was lying right there, like he's adding more onto that. But in my opinion, as a prosecution, I would just say that he added on to why he got mad. So is there a way I could to object that? Like a defense would say he's lying about that.
Okay, so you can object to questions. So and I'm not sure that the defense would ask the question in a way that would say, are you lying about that? Because you're trying to compare the police report to what the statement report would be. So if you had McKinney on the stand and got out the question, okay, he was with my friends and I walked up to him, and it may your answer would be that the police officer, that could have been told to the police officer and the police officer didn't write it down. But those are all closing arguments, not objections.
Okay, I see. Thank you. Sorry.
Yeah, objections are to questions. So like earlier we had a question asked a couple of times and someone asked, could I object, asked and answered? And the answer is absolutely. You would object, asked and answered because that question already came up. And a good way to find that objection is if you hear someone go again or for clarification. Okay, well then that means that you already asked that question. They just want the point driven home. So you would only object to questions. We don't really do objections during closing arguments. We just do responses. So as the prosecution, you're going to have a closing argument, and then the other side's going to get a closing argument, and then you have a rebuttal. So you can address anything. So that's how you address it rather than objecting.
Okay, Nika and then Tyler.
Okay, it's Naika.
Oh, I'm sorry.
It's okay. I know this question was a little it was asked before, but I kind of wanted clarification because you guys said that when Smalls said that because in their affidavit or their witness statement, Smalls says that he wasn't with McKinney's friends, he was just walking down the hall. And then, but in McKinney's statement, he says that Smalls was with his friends, and you guys said that Smalls, the attorney crossing Smalls could impeach Smalls on McKinney's statement. Is that like, because I thought that because that's McKinney's statement, I can't impeach someone else on what someone else said? Or, so can I get clarification on how that works or something like that?
Sure, you can impeach with anything, and you can try to impeach with anything. So you could say, here's the statement, isn't it true that you were with his friends? And the answer could be, well, I wasn't. So I'm sticking by what I said. I wasn't. Okay, that's the answer. So it's not always, you can impeach with it, but he has an out because he's not the one that said it. So it just depends if he says, oh yeah, that's right, I was with his friends. I wouldn't consider, or kind of like the question that came up about being on the team. Well, one person interpreted it as we played football during PE and one person interpreted it as being on the football team. So you could say, hey, they thought I was with them. I was not with them. So you can with it. It just, if it's not their specific statement, it's harder to get the whole, were you telling the truth then or were you telling the truth now kind of conundrum.
Okay. And then Tyler, you can unmute and ask your question.
Okay, thank you. Another thing about admitting evidence, can you omit evidence and not end up using it?
You can, but you shouldn't have admitted it in the first place then. You should know why you're admitting evidence.
Yeah, I do, but my thing is the only reason I'd want to bring in the police report is if the defense were to bring up something about the gun that he was threatened with. And that's the only reason I'd want to use it, because it stated in the police report that Small said he was going to bring, or Small said that McKinney was going to bring his older brother, but mentioned nothing about a gun in there, which I thought was odd that he'd mention it in his statement, but not the report like to a police officer. And that just didn't make any sense to me, but I wouldn't need to use that if nothing was brought up about the gun.
So go ahead, Felicia, you're going to say something.
Oh, no, it just, that her question makes sense, that you want to put in the police report, but if it's not brought up, then.
Yeah.
Well,
so is that okay?
Yeah, the police report will have other info that you might want to use, so you're still kind of using.
Yeah, there's a few other things I can use for if something is said by like their witness on cross-exam that I can bring up. But it's all if it's brought up. There's nothing in here that I actually need to say without it being brought up first. So is that okay just to have it admitted, but if it's not brought up, to not use it?
I would argue if you're asking to admit it in that circumstance, like you have a reason for admitting it. It may not come to fruition, but you're not admitting it just for the sake of admitting it.
Yeah.
Like you have a reason. So I
just need a good argument for the judge so I would just need to figure out the correct way to say why I want to admit it without quite saying I'm going to admit it just because I think something might be said.
I mean, you can just admit it and say, Your Honor, we have an unavailable witness. In light of that, I would ask that the police report of the officer be admitted.
Okay.
And that
makes sense.
That's not specific to like this police report. That's generally how you get police reports in for child abuse.
Okay, thank you.
Okay, is there any more question about questions?
Real quick before, since we have a little bit of a lull, I know some people are leaving early and I want to just make sure everyone hears this. If you guys are having like Wi-Fi connection issues the day of your scheduled mock trial, Patrick and Katya are going to be at the CCLF office. So if you guys need to use their Wi-Fi to have a stable connection for your trial, they will be open and you guys can do that. Just give them a heads up if you're going to be there. Like, I understand it's hard to know the day of, but even just like a text, hey, it's 6:30, my trial's at 7. I'm going to come over. That's all. I just want to make sure you guys do that.
Okay. So anything else on questions? No questions about objections? Okay. So closings. I need a closing from each side. Does anyone want to volunteer for the prosecution's closing? We'll do and this will be a little fun. So we'll do a closing on one side, a closing on the other, and then I'm going to ask for a special volunteer to do a rebuttal. And what the rebuttal means is you would listen to what the defense closes their argument and kind of respond to it inside of your argument. So it could be the same person that did the first one, or we can do 3 different, just give everybody a chance to kind of work out your kinks and your stuff before Monday, Tuesday, Wednesday, depending on what day your mock trial is. I keep saying Monday because I start Monday. My people are going Monday. So no one? Do I need to look it up and find out who's doing closings?
Jana, are you raising your hand with a question or do you want to volunteer?
I have a question. So sorry about objections.
Oh,
so when you have an objection, do you just like yell it out or like do you wait until they're done? Like what happens with objections?
No, you yell it out.
Okay, thank you.
So if I'm asking the question, so do me a favor, I'll show you how to do it. Go ahead and ask a question and I'll object to it.
how do you know Ronald Smalls?
Objection calls for speculation. That's not a good objection, by the way. But see how I kind of do it? I kind of listen to what your question's going to be. And as soon as I don't like it, I say objection.
Okay. Thank you. That makes sense.
And the good way is when you, now if you're objecting to the form of the question, that's how you do it. If you're objecting to an answer, you would listen, like if you were going to say hearsay, Lexi went over what that is. One really good way of catching that is hearing, well, she said, or he said, then you want to say objection before they can finish answering the question.
Right.
Yeah.
Okay.
So basically,
you.
yes, it's the part of the law where you just kind of yell out. And to answer your question, Philippe, what happens is I say objection, and like I did with Jana, I said what my basis was. Then she would get the chance to respond to it, so she can argue that her question is appropriate and it should be answered. And then the judge will decide whether or not it's the objection is sustained or overruled. So you get the opportunity to kind of argue back and forth at least once, probably just once to save time. But yeah, and you should do objections at mock trials this coming week. I want to hear objections. I don't want you guys to just let everything in. Even if you don't win every objection, you need good practice on it's good practice in mock trial to object at least once if you hear something that's not good. It'll help you practice. Okay.
Mackenzie, do you want to do your closing for the state?
Sure. Yeah. Should I start?
Yeah.
Oh, sorry. Ladies and gentlemen of the jury, the burden lies with the state to prove beyond a reasonable doubt that on February 5th, 2014, the defendant Ronald Smalls committed the crime of affray when he attacked the victim, Michael McKinney, at Minneco High School in Clark County, Nevada. We have met this burden. The judge in this case will instruct you on the elements of affray. Those elements require that we prove exactly what you have heard through testimony by the witnesses we presented. Over the course of this trial, you heard testimony from the victim, who testified about being brutally attacked by the defendant on February 5th, 2014. You heard additional testimony from the security guard who corroborated that this fight took place at Minneco High School. Mr. McKinney identified the defendant as the one who attacked him. Mr. McKinney also testified to the defendant's previous history with aggression and violence by forcefully tackling him during football training seasons. Regardless of any prior acts that may have happened, the evidence before you firmly shows that on February 5th, 2014, the defendant Ronald Smalls was the aggressor, and by doing so, he must now be held accountable for his crimes. In a few minutes, you will go back to the jury room where you can deliberate on all of this evidence. I ask that after you thoughtfully and carefully go through all of the evidence, you return the verdict that Ronald Smalls is guilty of the crime of affray. In closing, I would like to end this trial where I started, by offering my sincere thanks for your service as jurors in this difficult matter.
Okay. And I'm going to go ahead and assume that everything that you said, the facts, were actually brought out in trial. So we'll skip that part. But to that end, when you said that you heard the officer testify, you would just say in the officer's statement, you learned, because we only have the one witness. That's a change I would make. And then the other piece of it is, so closings are applying the law to the facts. So pull up the law on affray and say that we have proven that Ronald Smalls did, and then go through each element of the law. And that's how you make sure that you proved each element. Does that make sense?
Yes, thank you.
Yeah, I was just going to add that too, so I won't repeat it.
Okay. Do we have a defense attorney ready to do their closing? Okay, Jana, you want to try it?
Yeah. Should I just start?
Mhm.
Okay. Thank you for your time and patience and attention to the evidence presented. Good afternoon. My name is Jenna Hamdan, and I am the defense attorney in this case. Imagine that someone has threatened to bring their sibling to shoot you. How would you react? In this case that the prosecutor has presented to you today, there is insufficient proof to convict. We should ask for a verdict of not guilty. There is a lack of evidence to show that Mr. Smalls had created a disturbance of school. The burden of proof has not been met. Ronald had reacted to an unreasonable situation in the only way he knew, as any reasonable person would do. When threatened, Ronald had fought back. Before this fight, there had been a previous altercation between the subject minor, Ronald Smalls, and Michael McKenney. This had happened at the bus stop after school hours when McKenney had tried to fight the subject minor. However, the subject minor clearly stated, "I'm not gonna fight you." Later on, McKenney had made jokes in front of the subject minor, purposely aggravating him, and even threatened to bring my brother to shoot you, per Ronald's statement. Ronald Smalls has been the victim of this case, threatened by McKenney's words and actions. Smalls responded due to our human nature of fight or flight. I would ask you to empathize with Ronald and give him a verdict of not guilty. Thank you.
Okay. So this is just, and this isn't picking on you. I just want to bring it up generally. You just remind me of it. Slow down. I had this problem a lot when I first started doing like not even trial stuff, but just like oral arguments in front of, other people or presentations. A lot of you need to slow down. It's gonna feel like you're talking with like molasses in your mouth to you, but I promise it will help a lot. It allows you to punch your points home a little bit more. So not to pick on you again, I'm sorry, but I meant to bring that up earlier and you reminded me to bring it back up. It was good. It was good. You brought up the, the human aspect of it. He's just a kid. He was threatened. His brother was in danger. What would you have done? Couldn't get that sentence out. And the defense opening brought this up too. Generally, you're not allowed to say, well, jury, put yourself in the defendant's shoes. Like you would have done the same thing. You're not allowed to tell the jury, like, what would you have done in this situation? Like I said, you might be able to get away with it in mock trial, but that is objectionable by the prosecution. And the prosecution can, in your closing argument, object to stuff still. So just be careful. If you've got an attentive opposing counsel, they might object to that. But you did a good job, again, humanizing the defendant. And that's what you should do on the defense.
The only thing to go through, just to make sure that everything that you say actually got put in, I'll repeat that again. And then you called your client the subject minor. And I know that he's referred as such throughout, but to the defense attorney, Ronald or Rochelle Smalls is not a subject minor, is not a defendant. That's my client. That's the poor Mr. Smalls. That's however you want to identify him outside of subject minor or defendant. Okay. And that's part of the humanizing aspect of it. I want to hear every defense attorney calling them my client or by name, never subject minor or defendant. That's for the prosecution to call, to kind of do more of the dehumanizing on the other side. Okay. So does anyone want to try a rebuttal to that argument that Jenna just gave? Nobody has a response? Okay. I guess because that kind of sprung it on you, we can go over what would be in the rebuttal if I can't get anyone to volunteer to do it.
I could try, but I don't really know how good I'd be at it.
Oh no, that's what we're doing today, is just trying. So go ahead.
All right, sounds good. While the defense might have you believe that Ronald Smalls is a
human, and while humans all make mistakes, he is a 16-year-old boy in high school. At some point, people have to start paying for the consequences of their actions. He got in a fight twice at school on school property. At some point, there needs to be justification for that. So, while the defense might have you believe that he needs to be pleaded not guilty, through action, through this court, we can actually have him do better as a person. He's not going to jail. He's just getting volunteer hours. He's getting the help he needs. This is something that needs to happen.
So that was actually really good. That was actually really good. Bringing home the point that, you know, the actions have consequences, even bringing in the trial by peers part. So that was actually really good, Nikki. And it's what most people would probably hear in our cases.
Thank you. That was so nerve-wracking.
And you know what? That was a really good experience for you too. Just as a lawyer who does trials, sometimes you get the opportunity to give a speech without any sort of, we call it ambush, but any sort of preparation. Sometimes that happens where you're like, okay, we're ready for your closing now, or do the rebuttal now. Like, you understand when you are on the prosecution side and you are going to give the rebuttal, it rebuts what was said before. So there is no real way. I mean, you know your case, but there's no real way to write that out. It really is just what you did. I listened to what she said, and I'm going to tell you the opposite in a persuasive manner. So that's actually exactly how that goes. So you did it perfect.
Thank you so much.
Okay, so I wanted to leave some time for last minute questions, stuff that we need to go over.
Do we have class next Saturday?
No. This is your last class.
Why?
Because we went over everything, and then you guys are going to be doing your mock trials next week. So you'll be quite busy. Catherine, a video of a trial online to get familiar with the process. I'm not sure where a video would be available of a real trial, unless you have like access to True TV or something. But you might, I mean, if you want to watch something to get yourself familiar, that's fine. I don't know that we have the video available from last year, so okay. We did a mock trial last year, but I don't believe it was recorded. Isn't that right, Lexi?
We did record one, but I can't imagine that I can't access it anymore because I don't have access to Jabs.
Oh, okay. Okay, is it Ava? Ava? I'll go over real quick for an overview. So trial process is pretty much what we did today, just in tighter pieces. So the prosecution gets up and gives an opening statement. So if you're on the side of the prosecution, you and your co-counsel need to decide who does opening, who does closing. You'll give the opening statement. That's completely prepared statement. It's not an argument, it's a statement that evidence will show, just like the ones you guys heard today. And then the defense gets up and gives an opening statement. And again, not an argument, but the evidence will show stuff from the other side. Then the prosecution will call their first witness. And I believe we only have one witness. So you call the witness, direct examination, cross, depending on who your judge is, they might ask for a redirect. If not, then we switch to the defense calls their witness, direct exam, cross, any redirect. Then, since it's just the one witness, we go to closings. State gives the closing, defense gives the closing, and then state does that rebuttal. So that's kind of the trial in a nutshell.
Tyler, redirect, and then we'll get to the raise hands questions. Redirect is a opportunity that the prosecution can take. They don't have to, but it's available to them after the other side. Actually, it's not just the prosecution. Whichever side is doing the direct can do a redirect after the cross exam. The redirect is a opportunity for the side that called the witness to rehabilitate the witness after a cross exam. So, for example, if the opposing counsel, successfully impeached your witness, you don't want to leave the jury hearing that, like, oh, by the way, my witness isn't credible anymore because, they lied about something. You don't want to leave the jury with that. So redirect gives you the opportunity to kind of reestablish your witness's credibility or to talk about something a little bit more that the cross-examination might have brought up.
Is it common? Yes, in real life it is. In trial by peers, it just depends on the situation. I've sat over a lot of trials that did not have redirect questions. If you don't have any, you don't have any. It's an opportunity, like Lexi said.
Nikki and then Mackenzie.
Oh, I was just wondering if we could do like a prosecution, like how Tyler and I think her name was Elena did it, but if he could just finish his line of questioning so we could like get more examples.
I think Tyler did the
Yeah,
defense cross.
Yeah, he didn't get to finish, I don't think, because I think she impeached herself. So I was just wondering if he could finish it.
No, I did the prosecution cross, and I got completely confused there. So I don't know what happened, but I basically just stopped because I was making a fool of myself at that point.
You were not making a fool of yourself at all, for what it's worth. I mean, Tyler did most. You could consider what Tyler did the entirety of a prosecution cross exam.
Oh, so it really shouldn't be that long?
It doesn't have to be long. No,
okay.
And if you don't think it needs to be long, don't make it long just because you think it needs to be longer. A cross exam can be 1 or 2 questions. It doesn't have to be a series of 20.
And you don't need to lay the foundation with a cross exam, right?
Again, it depends. It depends on what you're trying to get out through the cross-examination.
Okay, that makes sense.
But you as the lawyer would lay whatever foundation you would need. Like, isn't it true that you were in PE with McKinney on Friday, January 4th? Yes, that's true. And isn't it true that at this PE class, you guys are playing flag football? Yes, that's true. That's how you would lay a foundation if you needed to on cross.
Okay, thank you.
Mackenzie, go ahead.
So I had a question. I don't know if this, if I just like skipped this part when I was reading over the case, but I read it over a few times and I don't, was the part about him getting his bigger brother and the fact that he said that he had a gun, was that in the case file or was that like a fact that was made up since it's a mock trial?
It was in the case file. I'm reading it from the police report. If you count the first 2 lines as a paragraph, it's in the bottom of the 3rd. Today, Smalls stated that when they saw each other, McKinney stated he was going to get his older brother. Smalls and McKinney then started to fight. Smalls provided a written statement. And so there's the brother. The brother having a gun, I believe, is in Smalls.
Oh, okay.
Yeah, bring my brother, he going to shoot.
Oh, okay, thank you. Also, I have another question.
Mhm.
So since we're doing the mock trial on Zoom, if you want, if you're asking for a moment of court's indulgence and you want to like talk to your co-counsel, could you text them about it, or like would you just like text them? Okay, thank you.
You
You might have to
text
because we're on. Sorry, go ahead.
Oh, you can text them. There's also a feature on Zoom that you can DM somebody in the chat. You could do that. I would just mute yourself if you decide to do that though.
Okay, thank you.
Because the idea is if they were sitting next to you, you'd be able to consult with them and whisper back and forth and pass notes. So you should be able to do whatever you need to do with your co-counsel in the virtuals as much as you could have in the real world.
Okay, thank you.
And Philippe, a court's indulgence lasts as long as you need it to. I've had some painfully long ones, but it's because you're asking for the moment, it's not a specific amount of time.
While the court's indulgence is like going on, does the other side continue or does it just awkward silence?
Awkward silence. It's just silent. That's why people are usually nervous not to make it go very long. But if you just need a moment, and real lawyers do it too. I mean, I know I hammered it home for you guys because I don't want you to either stop completely or get so thrown off that you don't accomplish your goal. I want you to take that moment because real attorneys do. The last trial I was in, the other side, we sat and waited for what seemed like a while, but she was speaking to her client quietly and needed time to make sure that she asked all the questions he wanted her to ask. So we just waited. I don't know about attendance. I think that's a Patrick or Katya question for attendance.
I have everyone. I just need to know who iPhone is. I sent them a private message and they didn't reply. So if your name is iPhone, tell me who you are.
I mean, I think I don't have anything to really part you with. I think we covered everything. Just be as ready for your mock trial next week as you feel like you need to be. If that means working today on it and working Sunday on it, if you're Monday, well, then you work on it Saturday and you work on it Sunday, just like a real attorney would.
Sophia, did you have something to say or ask?
No, sorry.
Okay. Okay, great. Well, good luck and we'll see you next week.
Yep. Have a good weekend, guys.
That's it. Just good luck.